So this is Doug Bradley, owner of OrangeCountyLawyers.com, and I'm here today with attorney Dr. Michael Ahmadshahi, who practices intellectual property law, more specifically law relating to patents, copyright, and trademarks. Michael, thank you so much for joining me today. I really appreciate your time.
My pleasure. Thank you, Doug.
Excellent, excellent. So, Michael, before we get started and kind of just to start into this conversation, I know that prior to becoming an attorney, you were employed as a scientist with a defense contractor, and you were also a research engineer with UC San Diego. And I was hoping to just kind of start there and see about how you transitioned into law.
Sure. I'll be happy to share that with you. Yes, I have several advanced degrees in engineering. In fact, prior to becoming an attorney, I was a staff scientist working for a defense contractor in Chicago. And prior to that, I was a research scientist at UCSD, University of California, San Diego. How I transitioned into law was really based on kind of working with a patent attorney that was getting patents for the company I worked for. And, that kind of prompted me to look into it a little bit more seriously. And throughout, my PhD program, a master's program, I had published papers, and I had a knack of writing articles that, even though they were kind of, you might say, dry, because they were, kind of scientific and
industry specific and
kind of interesting. So it would come out as something that would relate to layperson. So
Okay.
it would easier to read and understand. And so that's how I kind of thought, okay, this is maybe something I can do.
Okay.
And so that was really the transition. And to my surprise, actually, at the time when I applied to law school, I wasn't sure that whether or not this could be done, and whether I would be really one of the rare attorneys out there, a PhD program. But to my surprise, I found out there are actually in my area of practice, especially when it comes to the area of patents. There are a lot of attorneys with advanced degrees because some patents, I don't want to say most, are kind of technical, and so the attorney is more comfortable
Okay.
doing the patent application. And we get into maybe later what I do exactly, but it's advanced degrees are actually making it easier for me to practice law.
Okay. So since you kind of a good place to transition here would be more specific about your practice and kind of the process of getting a patent. I'm a big fan of the show Shark Tank, as I'm sure probably millions of other people are, and I always hear about them getting patents and different types of patents. Can you tell me and tell the viewers kind of what is the general process for getting a patent, and what are some of the things that you encounter for a client in the process of getting a patent?
Absolutely. By the way, I not only procure or get patents for inventors, but I also litigate intellectual property matters. And to that end, intellectual property involves four most common types of intellectual property are patents, trademarks, copyrights, and trade secrets.
Yeah, and I did want to get into litigation in a moment. I just wanted to kind of if somebody needs a patent or they're very interested in getting a patent, what's kind of the general process and timeline?
Okay, absolutely. And that's actually a question I get all the time.
Right.
When an inventor calls me and want to know what it actually takes to get a patent. How do you go about getting a patent? So the process is really a two-step process. The first step is to have an attorney, a patent attorney, or and in some instances, a patent agent, to write this patent application for you. Now, what is a patent application? It's really a document. It's a which you might just go on your computer and on a Word document write in basically a detailed description of the invention. And usually this detailed description of the invention involves drawings. And then following that description, you have a number of claims, which are really the part that you need a patent attorney or patent agent, a specialist, a skilled person to write these claims for you, because these claims really define legally what your invention is. And that is, in fact, it's those claims that you use to, for example, enforce your invention against potential copiers or infringers. The process is, like I said, the inventor comes to my office and we go over his or her invention. She tells me a brief description of the what she thinks is inventive, hasn't been done, and once we kind of come to an agreement that yes, this is a subject that we could probably pursue and file a patent application on, I'll take that brief description, and I write a few pages, depending on the complexity of the invention and the area of the art that we're talking about, whether it's mechanical, electrical, software such as apps. I know a lot of application programs are out there, apps they call them. Some of them, many of them are patentable and are patented. And other areas that are, for example, of composition of matter, which really pertains to pharmaceutical material,
biological,
such as pills and so on and so on. Once you prepare this document, which on average maybe about 15 pages of write-up of description, you file this with the U.S. Patent Office. Pay a filing fee, and this is now become a pending application. At the time you file this application, you get a patent pending number, you get a filing date, and then at that point you actually can proceed with what basically commercial exploitation they call them. You can go ahead and use your invention either in the form of making it yourself and selling it, or going around if you're looking for getting investors to invest in your idea, or outright licensing it or selling it to already existing manufacturers who are interested in your idea. Once the patent is filed, usually it takes about 2 months. Sometimes it's less, rarely it is less. Sometimes it's more, maybe about 18 months. So in about 12 months time, you get a response from the patent office that ordinarily this response is a negative one, in the sense that rarely does the examiner at the U.S. Patent Office outright approves your application. They ordinarily want to push back and kind of make sure your invention is not too broad. So that is the second step. So from the time you file the application until 12 months from that time, you get a kind of office action, they call them, from the patent office. That is the second step that you need to do. It's called the prosecution. It basically involves the patent attorney arguing or modifying the claims, those legal language that I was talking about in the beginning of this video, to basically get the patent application to issue as a patent. That is the second step, and it's the most important step. Tell clients, tell inventors that whoever you choose to be your patent attorney or patent agent, make sure they understand how to prosecute or how to get into a patent, because writing a patent application, although it is a prerequisite, you need to have a good application, good content. You need to have enough content in the patent application so that you can defend it. But once this is filed, you need to fight it. You need to get it through.
Okay,
and so that's the second part.
So
during anyone.
So during that process, that 12 to 18 month approval process before you get a pending status, what if somebody comes along, another inventor in a different part of the country or different part of the world or wherever, they come along and file, 6 months into your process or even a day after you've started the process or the filing, what happens in that scenario?
In that scenario, you win.
Okay.
So that's actually a good question you brought up. We had the U.S. was really the only country in the world that was that had the system of first inventor system, and the rest of the world was first to file system. That system changed also in the United States. So now we are on kind of harmonious and the same as the rest of the world, and it's called the first inventor to file. Okay. So whoever files first is entitled to the patent, whereas before, and that law passed in 2011, September 16, 2011, America Invents Act. Prior to 2011, if you could prove that you invented the invention first, obviously you had to have records, evidence, testimony, or what have you. If you could prove that you were the original inventor, you would be entitled to the patent, even though somebody filed before you. So in your example, now in 2018, if I file first, I win. The second filer is not entitled to the patent.
Okay, and tell me generally. I think probably a lot of inventors and a lot of people in general who'd be watching this would be interested to know what on average the cost is to achieve a patent or a patent pending from the day of start to the day of finish. Is that, I know that there's no magic number for every single scenario, but could you give us some guidance, or can you give us some measure as to how much it would cost for an inventor to really invest in a patent?
So we're talking about averages because the spectrum is quite wide.
I can imagine.
And I have written patent applications that cost a lot of money. Mm-hmm. But on average, a mechanical patent application costs anywhere between $4,000 to $6,000.
Okay.
And we're talking about attorney fees, and I would add another $1,000 worth of drawing and filing fees to these ranges. And that's a mechanical device that if you had an invention that did not require electronics. Now, when it comes to electronics, and so we have the mechanical art, we have the electronic art, and the software art is also can become expensive. I would add about $2,000 more on average to the mechanical one. So if mechanical invention costs between $4,000 to $6,000, a electrical invention could cost between $6,000 to $8,000.
Okay.
And the reason for that is you need to make the description more comprehensive. It takes more explanation. It takes more time to explain your invention. Okay. But again, some inventions are less, some inventions can be considerably more.
Understood. I can imagine that the complexity can drive the cost up, and
Exactly.
if you have someone who is also maybe trying to prevent you from getting your patent, then kind of, I guess, transitioning to litigation, that probably happens.
Absolutely.
And
So, mhm.
so kind of touching on that, and we have a few minutes left, and just to, I really kind of want to understand. So let's say we've gone through the process. I've got my patent. A year later, I notice
Mhm.
that there's knockoffs on the market, or there's somebody either blatantly or indirectly infringing on my patent.
Mhm.
What is my course of action at that time? What protects me, and how do you help in that scenario?
Okay. And as I said in the beginning of our video, I do uh, um, practice intellectual property litigation as well. I have represented plaintiffs and defendants in a intellectual property case. So again, focusing our attention on patents. If you are the plaintiff, you are a patent holder, and you know this. For example, you're selling your items on Amazon, and all of a sudden you see a very similar product showing up on Amazon, and you don't even know who this uh, company is. And so the process is first, you would probably need to have an attorney look at your patent and the accused device,
Mm-hmm.
the competitor's device, and kind of get an assessment of whether or not there is infringement.
Sure.
You don't really want to sue anybody in court or start the dispute without getting that preliminary information, because intellectual property cases can be very expensive. They involve reviewing review of many documents and so on and so forth. So you want to get an assessment. But let's say you do show the patent and the product to a patent attorney and get a assessment of if there is a likelihood of infringement. Then the next step is to send a letter that is a requirement that you need to tell the infringer that you think they are infringing on your
Mm-hmm.
patent, and it's a cease and desist letter or a
Sure.
demand letter, and you ask them to cease and desist from using infringing on your patent by stop selling, and you in fact uh, can ask for damages
That
uh,
was my next question.
for all the time that the infringer was infringing on your patent. So from, in fact, the amount of damages, and this is a little bit outside of what you asked me, can be more than from the time the patent is issued, because from the time you file the patent application, this is important because I said from the time you file the patent application, it takes at least 12 months to sometimes 2 years to get the patent. Throughout these 2 years, if an infringer starts infringing on your patent application,
Mm-hmm.
they may be liable and have to pay you all the profits, or one measure of damages, lost profits, for all that time that your patent was pending. So you can't sue anyone until the patent issues. But if you find out the infringer was infringing from the time you file the patent application, you can sue them for all that
Okay.
period. And so, yes, and so the process is to, if they don't stop infringing on your patent, you file a
Okay.
complaint in federal court, and litigation starts.
Wonderful.
That's on the side of plaintiff, and if you're the defendant, again, I represent defendant as well. So infringement is basically you can infringe either literally or by equivalence, they call them. So a patent usually is not literally infringed,
Mm-hmm.
but it's infringed by equivalence. In other words, even though the product is not exactly like your patent, if it is within the scope of your patent claims, then it is infringed, and it is infringed by equivalence, and the infringer is liable for damages.
Okay.
Damages
Well,
means
obviously,
money.
this could probably get very complex, and no situation is alike, and every scenario is probably unique, and I'm sure you come across this. The best thing I could tell to anybody who's listening to this video is that if you need more information on attorney Michael Ahmadshahi and his practice, you can go to mmaiplaw.com. That's mmaiplaw.com, and I'll put the link to his website in the description of this video, or you can call him directly at 800-747-6081, and you can click the link in the description of this video. And thank you again, Michael, for your time. I really appreciate it, and I'm sure our audience appreciates it. I'm sure you cleared up a lot of initial questions that an inventor may have. So thank you for your time.
I hope I did. Thank you, Doug.
Thank you. Have a great day.
You too.
All right, bye.